Thank you. Some of the legal issues discussed by Mr. Goldstein lead directly into the issue of eligibility for the various small case procedures proposed by the board, and we'll turn to the eligibility issue right now. First of all, although the interested parties do have extremely serious concerns over the level of the eligibility thresholds, we believe that the board is absolutely correct in proposing a bright line eligibility standard combined with an opportunity for the complainant to argue that its particular case should fall within the small case category. In fact, we believe that the lack of a bright line standard has been a major factor in shippers not utilizing the current rules. And Chairman Nottingham, I would certainly note your statement at the beginning that the board would like to bring some certainty to the question of who has access, and we certainly agree with that. But a presumed eligibility standard has to realistically evaluate the costs and risks of bringing a small case to the board and should cover the large majority of cases for whom a full standalone cost case would be too costly given the value of the case. It would entirely defeat the purpose of a bright line standard if most cases would have to argue that they qualify on the basis of an individualized determination. We see at least 5 problems with the board's proposed thresholds. The board, we think, has first of all underestimated the cost of a full SAC case. We think it's underestimated the cost of a simplified SAC case. We see problems with the board's aggregation rules. We see the issue of a risk factor and the issue of the maximum versus the actual value of the case. And we'll look, and Mr. Crowley, Mr. Fouth, and I will deal with each of these in turn. Concerning cost of SAC and simplified SAC, the board said in its July decision that a realistic cost of a full SAC case would be $3.5 million, and the board asked in its recent decision whether it has overestimated the cost of a full SAC case. We think the board, in fact, has underestimated the cost of a full SAC case. The most recent SAC decision entered by the board was in the Otter Tail Power case. And in view of the importance of this issue, I've been authorized by Otter Tail Power Company to tell the board that the cost to Otter Tail of the recent proceedings before the board was $4.5 million, or $1 million more than the cost assumed by the board in its July decision in this proceeding. The Otter Tail proceeding was not unusual. Although there were 3 supplementary filings in that case, they dealt with narrow issues and were not extensive. The record in that case is probably something like about here, and the supplementary filings actually are right here. You can probably barely see them over the lip. I would note that the board has recently suggested that Otter Tail, in fact, should have filed more expert evidence on one issue in the case. The cost of SAC cases has risen astronomically over the past 5 years and really has shown no signs of abating. You'll be hearing from Railroad Counsel later today, many of whom have litigated SAC in recent cases, and perhaps those parties may want to talk about their costs of litigation in recent SAC cases in order to give the board a realistic measure of SAC litigation costs. This raises the question of whether the board's recent rules in Ex Parte 657 will likely cut the cost of a SAC case and, derivatively, the cost of a simplified SAC case. And I would like to have Mr. Crowley SAC case. I turn to Mr. Crowley.
Thank you, Nicholas. I've been expect to spend in order to bring a rate reasonableness case under the board's proposed simplified SAC approach. The board has proposed that moves that have maximum value of cases between $200,000 and $3.5 million should be judged using the proposed simplified SAC procedures. The board has created these presumptive boundaries by assuming the minimum cost to bring a simplified SAC case will be $200,000 and the cost to present a full SAC case will be $3.5 million. Based on my experience in preparing evidence for every full SAC case heard before the ICC and the STB under the current guidelines, I believe the board has substantially underestimated the cost to bring both a simplified SAC case and a full SAC case. The board presumes that its recently adopted Ex Parte 657 SAC procedures will mitigate the cost of both full SAC and simplified SAC cases. I disagree. I will address the major changes brought about by the adoption of Ex Parte 657 procedures and describe, based on my years of experience, the impact the changes will have on the cost of a simplified SAC case. The first change was the allocation of revenues for SAR standalone crossover traffic. Historically, the ICC and the STB utilized a modified mileage prorate methodology to approximate market-based divisions negotiated between railroads to allocate crossover revenue. Such an approach correctly viewed the SAR as a replacement for the incumbent railroad and treated the divisions as what would be negotiated between two independent rail service providers. Under the new average total cost, or ATC approach, the shipper must take into consideration both the total on-SAR cost as well as the incumbent carrier's total off-SAR cost, including its variable cost and allocated fixed cost. This is done by calculating the on-SAR and off-SAR variable cost for each movement on the standalone railroad and allocating the incumbent's fixed cost based on a density-adjusted allocation approach. The change from a modified mileage prorate methodology to the ATC method adds a tremendous amount of complexity to the revenue allocation process in a full SAC case and is multiplied by several factors in a simplified SAC presentation. Unlike cold cases, which may have 200 movements or less in the SAR traffic group, a simplified SAC procedures will require the inclusion of all traffic moving over the SAR's route. This could mean the number of individual movements could number in the tens or hundreds of thousands when non-unit train manifest traffic is included. While the railroads have argued that they will have to perform the initial calculation of ATC divisions and therefore they are absorbing the cost of the proposed procedures, the shipper will still need to spend the time and effort to verify these calculations. This will require going back to the base revenue and cost data, verifying the selection and inclusion criteria, determining the routing and line density for each movement, and calculating the on-SAR and off-SAR variable and fixed costs. The only way to truly verify the railroad's data is to evaluate every step of the process used by the railroads. This verification process will be extremely burdensome in the simplified SAC process, given the large number of movements handled by the standalone railroad. Another item changed in Ex Parte 657 was the determination of the maximum rate. The board had historically used the percent reduction method to calculate the SAC rate. But as the board correctly observed, the percent reduction method was open to manipulation by the railroads, and the STB developed the maximum markup method, or MMM, as a replacement. I concur with the board that the MMM is a better approach for determining a maximum SAC rate, but the approach is much more time-consuming and costly to prepare than the percent reduction method. Unlike percent reduction, which only required the calculation of total standalone cost and aggregate SAR revenues to develop the SAC rate, the STB's MMM model requires evaluating the rate and cost of every move included in the SAR system. As I stated earlier, this could mean the inclusions of tens or hundreds of thousands of movements in the rate determination process, which will ultimately drive up the cost to prepare evidence. The next item change was a shift from the inclusion of movement-specific adjustments and the determination of a movement's variable cost to no movement-specific adjustments. The board made various justifications for disallowing the continued use of movement-specific adjustments, including a desire to reduce the cost of a maximum reasonable rate case. The calculation of variable cost in maximum reasonable rate cases has never been a driving cost factor. Rather, the cost of preparing the SAC evidence is the cost driver. In my opinion, the changes brought about in the Ex Parte 657 decision and the proposed changes in this rulemaking will raise the cost to prepare a case much more than any savings brought about by eliminating movement-specific adjustments to variable costs. The changes brought about by the ex parte 657 decision will, I believe, ultimately increase the cost to prepare evidence in a full SAC case or a simplified SAC case. In addition, other changes proposed by the board specific to this rulemaking will ultimately drive up the cost under simplified SAC even further. For example, the board proposes to require shippers and railroads to update their traffic and cost analyses annually to reflect any changes every year of the five-year prescribed rate period. As I explained above, the determination and verification of traffic, revenues, and costs will be one of the most costly areas of preparing a simplified SAC case, if not the most costly item. By asking the shipper to repeat this exercise an additional 4 times will unfairly drive up the cost of the case. Based on my experience, I estimate consulting fees alone for a simplified SAC case will range between $1 and $2 million. When legal and other costs are added, the cost of a simplified SAC case could abut the board's cost estimates for a full SAC case.
Chairman Nienham, Vice Chairman Buttrey, Commissioner Mulvey, it's an honor to be here today. As indicated by Mr. DeMichael and Mr. Goldstein, Mr. Crowley, and others, we believe the board's estimated $200,000 figure for a simplified SAC case is significantly underestimated, and I agree. In my previous testimony, I indicated that the proposed simplified SAC procedure is not a simplified and expedited method. I described in detail some of the time-consuming and costly work that would be required in a simplified SAC case. For example, the standalone cost railroad asset identification process has not been simplified, and this is one of the most time-consuming elements associated with a full SAC case. I submitted a detailed estimate of the economic consulting work that would be required in a simplified SAC case. I identified 6 phases and 62 individual work elements which would be required to complete a simplified SAC case. I estimated that the economic consulting fees alone would range between $500,000 and $1.25 million, but this excludes legal costs and the additional costs that Mr. Crowley has talked about associated with the 657 adjustments. Some of the railroads have criticized my estimates. However, none have submitted detailed estimates of their own. Moreover, as I pointed out in my rebuttal statement, adjusting for their criticisms would almost have no impact on my conservative estimates of between 3,000 and 7,000 hours of consulting time required in a simplified SAC case. Most of the Class 1 railroads have defended full SAC cases and at least know what their full SAC litigation costs are, which could have been introduced for comparison with shipper costs. The fact that none have done so infers that there's validity to our cost estimates. The board has failed to test simplified SAC. I believe adequate testing of simplified SAC would provide the board with a better understanding of the cost and complexity associated with the potential application of the procedure. The board's recent order asked for comments whether the board's $200,000 estimate was understated, assuming no rerouting of issue traffic. A no rerouting rule would not significantly reduce litigation expenses. The route evaluation and selection process would obviously be eliminated, but this would be only a small percentage of the total consulting and legal work required. The more important question here is, what is the trade-off? A no rerouting rule would likely result in higher rates in most cases. As I indicated in my previous comments, the existing route may not always be the most optimally efficient route. A no rerouting rule would force shippers to pay for such inefficiencies. The board also asked whether it should abandon the aggregation proposal. My answer is yes. Included in my opening statement is a detailed analysis of the potential impact of the board's aggregation proposal, which demonstrates that the proposal would likely eliminate a huge amount of traffic from challenge. Specifically, I developed the maximum value of a case, or MVC, for 42 individual movements of the same commodity from a single origin. On an individual movement basis, 32 movements would qualify for simplified SAC, 9 would qualify for 3 benchmark, and 2 would be forced to use a full SAC standard. Under the aggregation proposal, all would be forced to use a full SAC standard, even if it's too costly to use. The board indicates it is considering a case-by-case aggregation approach. The board would retain discretion to address cases where a complaint was disaggregating a larger dispute into a number of small disputes in order to manipulate the agency's process. I suppose this could happen, but I'm unaware of anyone ever trying to manipulate the board's processes in such a way. Such potential aggregation problems would certainly be rare. As such, I believe that automatic STB aggregation reviews of each case will be unnecessary, and that the board instead should simply revisit this issue if and when it proves to be a problem. Now turn it back to Mr. DeMichael.
Chairman Nottingham, the fourth eligibility matter that we'd like to discuss is the so-called risk factor. Some parties have urged the board to ignore this matter because it would get the board into speculating about the probability of success. I don't think this is correct at all. First, the board has already agreed with the need to recognize the risk of litigation. Back in 1996, the board declared that a rate complaint would not be cost-effective unless the value of the expected remedy exceeds the expected cost of obtaining a remedy by a sufficient margin to make it worthwhile to pursue the complaint. The board said if the cost of pursuing a complaint would consume most of the expected recovery, the remedy would be a, quote, hollow one. A risk factor is therefore necessary to avoid an outcome where the value of the complainant's recovery would not justify the cost of even meritorious litigation. Thus, the question really is how large should the risk factor be and whether the board should recognize a specific risk factor up front. Taking the second question first, we think the board should recognize a specific risk factor up front. The whole point of the board's proposal in this case is to establish a bright line of eligibility to make clear who is eligible and who is not. Failure to adopt a risk factor would undermine the whole purpose of a bright line standard and leave the parties in a land of uncertainty. Moreover, we think that it's clear that a risk factor of 2 is not sufficient to achieve the, quote, sufficient margin, close quote, that the board discussed in 1996. Of the last 7 SAC decisions, 2 have resulted in some relief for the shipper. And the lack of a small case precedent itself argues for a substantial risk factor because the uncertainties of the small cases at this point appear much greater than the uncertainties even of large cases. Clearly, large cases have certain risks, and small cases at this point, given the uncertainties, have even more. Finally, we want to discuss the maximum value of a case concept. As the MVC concept was stated in the July proposal, it did not take into account the fact that both the simplified SAC procedure and the 3 benchmark procedure would not produce rates anywhere near the 180% revenue to variable cost level. The interested parties have partially adopted a railroad suggestion that as long as the board has developed reasonable thresholds on the basis of a realistic cost of litigation and the recognition of a reasonable risk factor and eliminated the aggregation rule so you can get as well as access to needed information, the problem with the MVC concept as proposed can be partially alleviated by the shipper being able to specify a case-specific MVC. In its recent decision, the board suggested a small claims model whereby the board would put a limit on the amount of relief available under the various procedures. Just a few comments on that. We think the fairness of this procedure still depends, first of all, on the recognition by the board of a realistic cost of litigation and a realistic litigation risk factor, elimination of the aggregation rule, the things we just talked about. We also agree that the board's suggestion that a complaint that a complainant will need to be able to amend its complaint if the value of the case turns out to be more or less than originally contemplated, and the board has stated that in its recent decision. The interested parties will be addressing this matter further on February 26th, but with these caveats, the interested parties are not opposed to exploring the board's suggestion as a possible useful approach. Regarding eligibility, then, in summary, we think that the board's general concept that there should be a bright line of eligibility is correct, combined with an opportunity to argue case specifics. We think that the MVC calculation should be revised, as I mentioned before. We think that a realistic cost of a full SAC litigation should be determined to be $4.5 million, and a realistic cost of a simplified SAC, considering the uncertainties, should be determined to be $3.5 million. We agree the board should eliminate the aggregation rule, and in light of the caveats above, the presumed eligibility for full SAC should be $13.5 million, and for simplified SAC should be $10.55 million. Let me turn to discuss certain aspects of the board's simplified SAC proposal. In our written comments, we presented in detail why the board's simplified SAC proposal should be withdrawn. Candidly, we believe the proposal is unfortunately just not ready for prime time. There are two aspects we'd like to highlight: the lack of testing, which the Department of Transportation talked about in some detail, and secondly, what appears to be a systematic skewing of the proposal that is inconsistent with the underlying principles of constrained market pricing and specifically standalone cost. I'd like Mr. Fouth to talk briefly about the issue of lack of testing.
I urge the board to consider the fact that the board's proposed simplified SAC procedure has not been adequately tested to verify that it is truly a simplified and expedited method, that it is a viable and workable approach, that it produces reasonable and realistic results, and that it will protect captive shippers from paying unnecessarily high rates. You should be concerned by this fact. One of the primary reasons that the ICC and STB and the court rejected the AAR's previously proposed simplified SAC procedure was the fact that ICC testing of the approach in the 1990s indicated that it resulted in revenue cost ratios exceeding 5,000%. How do we know that the board's proposed simplified SAC procedure will not produce similar results? The railroads maintain that the simplified SAC requires no special testing because it is based on CMP and the SAC constraint. Simplified SAC may have a similar name and some of the same elements as CMP and SAC, but it does not replicate and indeed significantly departs from CMP and SAC. The board could test the proposed simplified SAC procedure using the record and results in recent full SAC cases referenced by the board. However, testing the procedure on non-coal movements, which are more likely to use the procedures, is equally, if not more important. DOT agrees with the interested parties on this point. DOT states such an exercise would disclose whether SSAC, as proposed, would introduce biases favoring any particular party. It should be the board's responsibility to perform or supervise such testing. It would be very difficult for any independent party without access to internal railroad data to adequately perform such testing from publicly available information. Were the board to undertake testing, I believe the board would discover that the proposed simplified SAC procedure is far less simplified than the board suggests. Thank you.
I want to just very briefly, in light of the time, talk about some of the procedures that the board has proposed as far as its simplified SAC, and the fact that they seem to be consistently inconsistent with the SAC, especially in one direction. The board has said that basically all traffic needs to be included in the simplified SAC procedure, whereas in the SAC test itself, it said that grouping was essential to the theory of contestability, and without grouping, SAC would not be a very useful test. The board's simplified SAC procedure basically forces the shipper to use the existing traffic on the line, thereby eliminating the possibility of achieving efficiencies in the grouping. I would note on this that there's obviously a tension here between simplification and accurate results. There is at least possibilities that a simplification may not produce them. What we seem to be having here, though, is a consistent skewing, biasing, in a sense, of the procedures to produce a higher answer. And it's a very troubling problem because we don't know, as Mr. Fouts said, just how this is going to work, and without testing, we don't know the result and the extent to which the board's proposed simplified SAC procedures would actually replicate, or how accurately they would replicate the results of a full SAC. The interested parties do not oppose simplification. They want simplification. That's what we've been talking about for the last half hour. But simplification without any testing that would permit the community to know what the answer produced by the procedures is just not right. Simplification without demonstrated fairness is not a sound basis, we think, for a small case procedure. Let me turn in the remaining time to the three benchmark approach. The board asked for some comments on a couple of aspects of the three benchmark approach, especially the issue of ratcheting under the three benchmark approach, and the interested parties have some serious concerns with the issue of a confidence interval. And I'd like to ask Mr. Crowley to address both the ratcheting question and the confidence interval matter.
The Class 1 railroads have argued in their various filings in this rulemaking that the repeated application of the three benchmark method to the higher rates in the comparison group will reduce both the mean rate and the upper bound of the confidence interval of the comparison group and drive those rates towards the mean. In truth, the railroad's ratcheting arguments are based on several unproven assumptions. First, the railroads assume that a comparison group is a unique and static entity in which all members of a comparison group for one movement will also be in the comparison group for every member of the original group. This clearly may not be true. For example, assume a shipper with a 500-mile movement brings a rate case using the three benchmark approach, and included in the comparison group are 10 movements. The comparison group movements have the same operating characteristic as the issue movement, but their movement miles range from 475 miles to 525 miles. In other words, the comparison group miles are 5% greater or less than the issue movement miles. Now assume the shipper with the 525-mile movement in the original comparison group decides to bring a rate case under the proposed three benchmark approach. Under the railroad's way of thinking, the comparison group with the prior case would also be the comparison group for this new rate case. This may not be the fact. If we use the same plus or minus 5% mileage range as a way to identify movements for the second comparison group, the mileages would range for this new comparison from approximately 500 miles to 551 miles. This new comparison group would exclude some of the movements from their prior group and may or may not bring rate relief for the shipper. This is because comparison groups are not mutually exclusive groupings that will always contain the same members. Comparison group membership can and will overlap, leading to different group compositions and no guarantee of a ratcheting down of rates. My next problem with the railroad's arguments is their assumption of an instantaneous impact on a rate judged unreasonable under the three benchmark approach on other members of the comparison group. In truth, the impact of a prescribed rate will not occur for at least a year due to the lag in the production of the STB's waybill sample. It may not be included at all if the prescribed rate is excluded from the waybill sample. The latter may be entirely possible due to the stratified sampling pattern used to create the waybill sample and the small size of shippers using the 3 benchmark method. In addition, rates are not static on a year-to-year basis, and while a comparison group may provide relief in 1 year, in the following year the rates may have changed to such an extent that relief would not be forthcoming for the comparison group, even with the inclusion of the new prescribed rate. As I stated earlier, comparison groups are not static, unchanging entities, and the inclusion of a prescribed rate in a comparison group will not necessarily lead to another finding of rate unreasonableness for another member of the group. The next issue I've been asked to discuss is the addition of confidence interval on top of the average RBC calculation under the 3 benchmark approach. As I explained in my verified statement submitted as part of the interested party's opening statement in this rulemaking, I do not believe that the use of a confidence interval calculation as proposed by the board is valid due to the non-random nature of the comparison group. Some of the railroads have argued that because the STB's waybill sample approximates a random sample, that the use of a confidence interval is appropriate. Whether the issue waybill sample is truly random or not is debatable. This was never the issue. Rather, the issue was whether the comparison group was random, which it clearly is not. Simply stated, a non-random subsample drawn from a presumably random sample does not make the subsample random. It is on this basis that I believe the STB's proposed methodology is in error.
Chairman Nottingham, I can't quite see the lights here, so I'm not sure whether I have time or not.
We do have I'm advised, a temporary technical problem with the lights. I can give you just my own timekeeping sense, which is that you are at the 45-minute mark right now.
That's fine.
I'd be happy to give you a minute to conclude if you'd like.
Surely. Thank you very much. We do, as I said, want to thank the board for its time and attention in this case. We think these are very, very important issues, and we're very, very pleased to be here. We certainly look forward to any questions that the board has. Thank you.
Thank you. One of the issues that has been touched on by a number of witnesses today, and certainly was one that we called attention to in our recent notice, is the usefulness potentially or potentially lack of usefulness. We do want to hear on this, and we have heard some of mediation. I wanted to give Mr. Crowley in particular, I understand, has some experience with mediation, and invite anyone else after Mr. Crowley responds to just comment on that issue.
I think mediation, it has some benefit in the big cases. I'm not sure of the benefit in a small case. You could easily run up the cost of litigating a small case through the mediation process, and then have to turn and litigate again, which would double the cost and make it somewhat impractical.
I would just maybe add, though, that we think that a mediation proposal would need to be quick and therefore inexpensive to be useful. The AAR suggested a 20-day period. If we can hold a mediation to that kind of quick time period, that might well be a proposal that would appear to make some sense. But I think you have to be careful that the mediation process does not sort of get out of hand and just drive up the cost of a small case.
Any other comments on that? I know I do, in a variety of areas of the board's work, I give a lot of thought to the costs that our work, our decisions, our proposals might be imposing on parties, on the economy overall. I'm sure my colleagues give a lot of thought to that issue as well. and I recognize that in a free society, in a free economy, the government ought not typically to restrict what a private person may choose to spend on a lawful exercise of exploring the fairness or merits or demerits. However, that being said, there's been a lot of commentary already, and I'll certainly explore this issue with other panels, I'm sure, about the costs of pursuing rate claim dispute resolution through the board's processes, both actual past costs and potential costs under our recently concluded large rate case rule and also under this proposed rule. Help me just think through. I would just welcome any of the, we have a range of witnesses from folks perhaps on my far left who work for businesses who actually pay the bills, to folks on the down the row who may have another vantage point, receiving the fees, so to speak. And where should the board turn for impartial analysis, advice? Should we be concerned that some parties who have very strong and apparently thoughtful opinions on this issue also have a lot at stake, both personally from a pecuniary perspective, and where should we and perhaps shippers and railroads, folks who are paying these bills, turn for kind of that impartial sort of cost estimate as to what are the costs of these board procedures? Because I worry that we could even give it our best shot and come up with just what we think is the perfect balance. But guess what? We don't always necessarily feel in control of the actual bills that get sent out. That's a matter of private contract, private agreement, presumably. And I'd also like, I know it's a long question, I'll wrap it up, but would like to know if anyone's willing. There's been some willingness today to talk about actual litigation costs in specific cases. I heard the Otter Tail, that was of interest. Is there any use out in the marketplace of sort of fixed fee type arrangements between lawyers and consultants and shippers and or railroads where the bill payer gets some level of certainty as to going in as to what their exposure might be? I welcome any of the panelists to try to address any of the issues I've just touched on.
Let me partially try to respond to that, Mr. Chairman. It's been my experience that fixed fees are not generally employed in litigation because you cannot predict what the other side is going to do. And so that's the reason why attorneys in these types of proceedings charge on an hourly basis. And I wish that we could overcome that. I think everyone would love to have a fixed fee situation, but it's not economically real. And I think that the Otter Tail experience has been particularly enlightening. That's a real life example of what a case cost. I don't think that the cost consultants who have put in estimates of the number of hours really would be acting in their own self-interest to build up their costs unnecessarily of a proceeding, because it'll just drive their clients away. I think that everyone wishes it could be done for a lot less money, so that our statements about the costs, the high costs, are in many respects contrary to our own self-interest. We would like to see lower costs.
I would just add perhaps a little bit about that also. I very much agree, and it's very difficult in litigation to determine what the costs are going to be. I think, frankly, SAC cases, the history of them have been that parties have indicated that SAC cases will be less than they have been, and they turn out to be more. I was reading the board's 1996 decision the other night, and the board in that case was talking about the cost of a SAC case back in 1995 being somewhere between $250,000 and $1 million. And there was some dispute back then whether the $1 million was right. But even if it was, SAC cases have just in 10 years quadrupled or quintupled or more. And this is a result of the dynamic that has in these cases. Parties will put in, X evidence, and you didn't expect that, and so you have to respond with Y evidence, and it just keeps going up and up and up. And I think that's a real issue with the board's simplified SAC proposal. It looks, if you look at it fast, it might work cheaper. But I think the same dynamic, which has been at work for the past 15 or 20 years in SAC, is going to be precisely at work in some simplified SAC, where things that start out looking inexpensive or maybe inexpensive, especially if you don't really test them out, after a while it becomes much more expensive. So there is kind of a litigation risk factor in the simplified SAC proposal itself that I think is going to tend to drive things more expensively rather than less.
And I think that will be especially true for the first cases that may be decided, because they will be extremely heavily contested, and every single imaginable argument is going to be raised by the parties.
Yeah, I believe part of your question, Chairman Nottingham, was what would shippers be willing to pay? My particular employer, we have master contracts with most of the Class I railroads. Only one of those contracts is a 5-year contract. Two of them are 2-year contracts. The rest are all 1. So from a practical standpoint, if you're talking a cost even as low as, say, $500,000 for something like this, you have to question whether it's really worth doing it.
Okay. There was some reference, I think, by one of the witnesses to perhaps more to the perceived desirability of the railroads divulging their actual litigation and consultant expenses in these cases. Just be curious to ask anyone on the panel who'd like to respond. If a railroad were to take you up on that invitation and enter a number into the record today or later, can we expect that you would accept that at face value and that would be the end of the discussion on what railroad costs, or do we then have to go into some type of elaborate discovery process or something? Just sort of want to know where we go if we do think deeply on that topic. Anyone care to opine?
I've indicated what the otter tail costs were. I think it would be. I would certainly hope that the railroads would believe that that's the cost. I think that is the cost. I would accept. I would believe that they should be equally as candid, and I think their costs are going to be similar or perhaps even higher.
Vice Chairman Buttry, questions?
Thank you, Mr. Chairman. We got into this morning sort of what I would call the academic part of this discussion pretty quickly, and that's a very important process that we go through here is the academic and technical part. But there's a grassroots part to this component to this issue as well, and that is this term that's sort of crept into the dialogue in this city in the last few days and weeks about who will be the decider, and it raises an issue in my mind, especially that was brought to light especially this week by a letter that I received from a shipper that I will not mention the name, of course, or the location in the country, and the concern that shipper had about being able to stay in business. So we get quickly transported from the academic part of this discussion to the grassroots part of this discussion. And I'd like to direct my question to Mr. Mack and Mr. Goldstein primarily. It concerns me that the carriers might be in a position to decide, to be the decider, if you will, of who stays in business and who doesn't. And I think it's an accepted fact in this country that small businesses play a huge role in this country, in the economy of this country, and a huge percentage, the preponderance of employees in this country are employees of small businesses. And some of those small businesses are captive rail shippers. So it behooves us to come up with some approach to this issue that gets to the grassroots, ground level of this issue. And it concerns me, this issue of who will be the decider of who stays in business and who doesn't concerns me. And if you would, Mr. Mack or Mr. Goldstein, add any observations or comments that you might have to what I've said.
I'll make a comment on that remark. You know, I think there's a lot of truth in your statements in regard to rail rates drive a lot of business. Transportation rates drive a lot of business, not necessarily just rail rates, but transportation is a significant cost. My sense is that when there is something that is completely out of the ordinary, that there needs to be some mechanism outside of one of those small businesses that you described to completely change their way they do business, you know, completely or go out of business. There needs to be some mechanism that can address the issue at heart if that in fact is a transportation cost issue. And at least in an attempt to take a look at a situation that maybe a particular movement has been demarketed by a carrier. So the point being that I think relief options need to be presented, and they need to be at a point where it's at least an option to attempt versus no alternative at all. And I think that's what we're seeking.
I think the problem you're raising is a vital problem, and I think it's becoming more acute as railroad capacity is smaller in relation to demand. And as railroads can afford to become more selective in the traffic that they want to handle. And so Dan used the term demarketing. What he's referring to is that we see quotations from railroads, rate quotations, which are deliberately set at a level that is so high that they know the traffic won't move. And it's possible that the proceedings in this case may provide an answer to some of those problems. We often hear the railroads say that what we're talking about right now isn't really a problem because their customers are so much bigger than they are. What we're really talking about, though, is not the size of a customer and whether the customer itself is big enough to take care of itself, as the railroads like to say, but whether the facility fits into, that customer's facility fits into the railroad's plans. Railroads see that facility as being either inefficient as a contributor of traffic or unnecessary because they can source the amount of traffic that their destinations need from someplace else. And it's a real problem. I'm not sure that the entire problem can be addressed through rate relief, but I think to some extent it can be.
Anyone else like to speak to that issue? Thank you, Mr. Chairman.
Commissioner Mulvey?
Thank you, Mr. Chairman. I'm a little disappointed today that the testimonies did not really focus on our revised January 22nd, 07 decision. I appreciate that there'll be further evidence, testimony submitted later on, and I look forward to reading that, but I was hoping that it would focus on some of those things that was raised in our decision today. Having said that, I'd like you all to respond to the proposal that we allow the shippers to choose amongst the three: full sack, modified, simplified sack, or three benchmark approach, and decide in advance what they think the value of the case would be, and proceeding with that proposal in particular, because that seems to get away from some of the eligibility issues, if you would. Mr. DeMarco, you want to start?
Yes, I briefly dealt with this in prepared remarks, but I think basically we see that there is some real possibilities in that, but we in that approach it certainly gets away from the problems of maximum value of the case versus actual value of the case. I think, though, for it to be workable, as I mentioned, it I think needs to recognize a realistic litigation cost, realistic litigation factor. Those the numbers need to be, in a sense, linked to those kind of realistic things in order for them to be workable. I hesitate to kind of give you kind of a final word now, because we would like to think this through. But it seems to us to have some benefit, some promise, assuming those caveats would be included.
Mm-hmm. Yeah, I should point out too, the 22nd of January, it was only 9-10 days ago, so 9 days ago, so therefore you didn't have all that much time to prepare, and that's unfortunate. But these proposals that have been advanced, I think, are substantial departures from our original NPRM, and they are proposals that we really want to get more feedback on. Let me ask, Mr. Mack, you mentioned the arbitration process used at the Ngfa. Could you elaborate a little more on how that differs from what we're proposing for mediation?
The one key difference, of course, is that rail rates are not a topic that can be arbitrated under the rules of the Ngfa rail arbitration.
I understand that, yeah, but in terms of procedures.
In terms of procedures, I'm not 100% sure on the mediation, and if someone else could defer, I could defer to that.
The Ngfa arbitration procedures are far less formal than any of the procedures that have been proposed for small rate cases. They are normally, in fact, I'm not aware that there's ever been discovery involved in them. They are normally handled by the submission of opening, reply, and then rebuttal comments, and they're generally decided within 6 months. So in some respects, in fact, many respects, it's a much more simplified. But as Dan said, they don't get to the issue of rates. They deal with such things as loss and damage claims, unreasonable practices, and the like, which may be simpler concepts than rates.
Thank you. Mr. Crowley, you were mentioning the costs associated with the simplified SAC procedures and also the changes that were proposed by in Ex Parte 657. In terms of crossover traffic and the allocation of revenues to crossover traffic, you mentioned that you admit that the railroads are the ones who are responsible for developing that data, but then you have to verify the data. Now that could be very, very expensive, but couldn't you take a sample? You don't need. You mentioned that you have to verify every single piece of data, but wouldn't sampling be cheaper, more efficient, and just as accurate? I mean, you're a statistician, so.
Well, sampling is always a technique that can be used to verify data, assuming you have the universe to sample from. But my concern would be that the information that you get to sample is simply the result of the railroad's analysis and not of the selection criteria they used or the elimination criteria they used in evaluating the traffic. If I'm asked to represent to one of my clients that the calculations and the procedures followed by the railroad are accurate, I think you have to get to the root data in order to make that representation. Now, if the sampling procedures were coupled with access to the root data, I think you might be onto something.
Okay. Every time we try to make things simpler, we seem to make them more complicated and more expensive. Every time we try to make them cheaper. I'm sad to hear that you all think that the changes that were proposed in Ex Parte 657 on the large SAC cases has not lowered the cost. But on the Some of the issues in the full SAC case that will be reduced or eliminated using a simplified SAC methodology. I had the staff prepare a list of all the things that would no longer need to be done, or the cost of which will be very, very much reduced, and they do seem to be substantial. There's the jurisdictional threshold, for example, simply we use an unadjusted IRCS. The SALT configuration of route and track miles, we're now going to use the predominant route or traffic, so you don't need to specify a route or figure out what route you might want to take. The traffic volumes and revenues are defined by actual traffic for the most part, or in some cases, like the rerouted traffic would no longer be an issue. Using actual miles. Operating expenses would all be based upon modified IRCS operating expenses using actual traffic. You wouldn't need to postulate a hypothetical railroad, for example, and all those operating expenses would no longer be modeled. On-road property investment using rolling averages from prior cases, again, would simplify and I would think reduce the cost. In fact, the only one that has no change in that category seems to be tunnels, and tunnels tend not to be typical, especially in western cases. Discount the cash flow analysis, again, reduced to a one-year DCF, no debates over refinancing debt under the new proposals, et cetera. All of these would seem to substantially reduce the case, the cost of bringing these cases. Anyone want to respond to that?
I agree that those things will reduce the cost if you're starting at the right point. I think we heard this morning what it cost to litigate the Otter Tail case. And I was part of that case. And what I'm telling you is that the cost of bringing a simplified standalone case is half of that, maybe less than half of that, maybe a quarter of that. But that's still a substantial amount of money. The things that you mentioned on your list are simpler, but still require calculations. The things that you didn't mention and that I didn't mention in my prepared remarks that are going to be very cumbersome, in addition to what I said, are things like grading. We're going to use the engineering approach as the guidelines suggest, except for those places where there aren't engineering reports. And the engineering reports are not all encompassing. To do an actual grading estimate is very complicated and very controversial. The cross-subsidy testing, the more moves you have in your universe or in your SAC group, the more difficult it is to do the cross-subsidy testing. That's going to be more complicated as well. So while there are some things that are simple, I think we've taken that into account in giving you our best guess as what it's going to cost to litigate these things.
I would perhaps just add to that also that